The case I chose to analyze this semester for my final paper was the New York Times versus Sullivan case of 1964. I will begin by discussing a general overview of the case. Following that, I will discuss each side of the case, the outcome of it, as well as its significance. It is important to note that this case was ongoing during a time of high civil stress throughout the nation. Leaders like Martin Luther King Jr. were prevalent civil rights activists at the time. According to Britannica, this case developed from the result of a civil rights protest in Alabama in which some of the protesters were attacked by Ku Klux Klan members. Police misconduct was also evident during this time. As a result of the incident at the protest, an advertisement was developed and published in the New York Times. The advertisement was titled "Heed Their Rising Voices," and it demonstrated high support for civil rights activists in the South. It mentioned police misconduct, and although it never directly mentioned L.B. Sullivan, he claimed in his case he was identifiable regardless. L.B. Sullivan was a former commissioner of public affairs at the time of the incident of police misconduct. One of the roles as commissioner of public affairs was the supervision of the police department. Sullivan claimed that the advertisement contained false statements and were damaging to his reputation and demanded compensation. According to the Tedford and Herbeck text, a civil libel suit ensued, and the judge and jury of an Alabama court agreed with Sullivan, awarding him $500,000. The Alabama Supreme Court affirmed this decision. The New York Times, according to the Bill of Rights Institute, took the case to the U.S. Supreme Court, where the decision of the previous courts was reversed. The New York Times argued in their defense they never meant any harm towards L.B. Sullivan. The advertisement had a large number of protesters' signatures on it as a representation for support for civil rights leaders. Because of this, according to Britannica and the Tedford and Herbeck text, the New York Times stated they had no reason to believe the advertisement contained any false information. Therefore, they did not check the accuracy of the statements, even though, according to Britannica, they had an entire department dedicated for that reason. The New York Times claimed if they were obligated to check the accuracy of every article criticizing a public official, the freedom of press would be severely limited. The U.S. Supreme Court agreed and reversed this decision. It is important to note here that previously, Alabama had a law that only protected opinion of people and press when their opinion was reliant on complete accuracy of their facts. This, according to Tedford and Herbeck, was the first time the First Amendment protection was extended towards a specific type of defamatory speech, that being criticism of public officials. Furthermore, the Supreme Court ruled that libel action of public officials would not be tolerated unless public officials took the full responsibility of demonstrating defamation was communicated with actual malice. According to Tedford and Herbeck text, Justice Brennan delivered the opinion of the court. In his speech, he claimed a rule needed to be developed in which the critics of official conduct would not be deterred from voicing their criticisms. It is stated in the same text that Justice Black, Douglas, and Goldberg wanted to go further in this case to guarantee complete protection for speech critical of the government and its officials, where not even proof of actual malice could alter that privilege. The most significant outcome of this case was, in fact, the development of the actual malice rule. The rule states that public officials would not recover damages for any defamatory speech containing falsehoods, unless that public official could prove the statements were published with knowledge that the information was false, or with reckless disregard for its truth. According to the Forbes magazine, this case, being more than 50 years over, still holds extreme importance in cases today. It still holds that public debate should be remained uninhibited, robust, and wide open. It also claims that because of this case, the press still today plays an integral role in public debate of political issues and officials. We read in the Freedom for the Thought That We Hate, the press has a responsibility to its citizens as an alliance. It also keeps checks on the government. I could not think of a better case that better represents this. I look forward to further analyzing this case and discovering more about the impact it has on the lives of people today. Thank you for taking the time to listen to my video. Have a good day.